Hello, everyone, and welcome to Uncivil Law. For today's case, we're dealing with Baltimore City gangs and whether or not a gang member's conviction was proper because of things that happened to the jury that might have caused it to reach an improper result. This is the case of United States of America versus Gerald Thompson Johnson. In this case, Mr. Johnson was being convicted of being associated with a gang, and there were some things that happened during the trial that caused the jury to perhaps not reach a fair verdict. So the Court of Appeals is looking at this decision and trying to determine whether or not this purported Baltimore gang member should get another bite at his criminal conviction apple. Let's get started with this. Johnson, Jones, and 7 co-defendants were indicted on numerous charges arising from unlawful activities convicted by members of the BGF, which is a criminal gang inside of Baltimore, of which Johnson was a high-level leader. Johnson and Jones, collectively the defendants, were both charged with conspiracy to participate in racketeering in violation of RICO. Criminal RICO. This is what RICO was designed for. Gangs. The mafia. This is exactly what RICO was designed for. So this is a case where not only is it RICO, this is exactly what RICO was intended to do. As well as conspiracy to distribute and possess with intent to distribute heroin, cocaine, and other controlled substances. Johnson was also charged with conspiracy to commit murder in aid of the racketeering and murder in aid of racketeering in violation of law and additional drug and ammunition offenses. So our defendant here, the protagonist of our case, I suppose, the protagonist of our case here, has been doing many, many not good things. He's been affiliated with a gang that's involved in racketeering organization. He's been distributing drugs, and he's committed murder. So, not great. This is the guy we want to criminally convict. Okay. The government introduced evidence at trial that showed that for more than a decade, the defendants committed numerous crimes on behalf of the gang. Johnson acted as a leader of the gang, overseeing an extensive drug distribution operation and attendant acts of violence. The jury heard evidence that Jones was involved in murders and shootings of several people, which were directed by Johnson and other members of the gang. The government recounted the gang's many efforts to shield the gang's illegal activities by terrorizing those who dared to cooperate with the police. Gang members using intimidation to protect their turf in operation. Multiple witnesses detailed the strict rule against snitching. Snitches indeed get stitches if it's in Baltimore, yes, which the gang treated as punishable by death. According to government witnesses, Johnson ordered the murder of 2 individuals who the gang believed were cooperating with law enforcement. Johnson committed one of these murders. So, yeah, so we're killing people who are potential witnesses against us, which incidentally is also a capital crime in most jurisdictions. So when you're looking to elevate it from routine murder to capital murder, death penalty level murder, one of the things that will typically get you there is if you are killing the witness to a crime. And so this would be an example of that. So we have gone beyond murder 2 to murder 1, capital murder in most places because of killing a witness to a crime. The murder of Moses Malone, a government cooperator, was at the heart of the government's case and formed the basis for Johnson's charge of conspiracy to commit the murder in aid of racketeering and murder in aid of racketeering. So we've got conspiracy to commit the murder and the actual murder. So we're charging with 2 things: conspiracy to commit murder and the actual murder. Okay. Malone had been the victim of a robbery and non-lethal shooting allegedly committed by the gang. Following that incident, Malone identified the perpetrator of the robbery in a photo array compiled by law enforcement. Malone also identified Johnson as the person who's likely to commit the crime. So this person was hurt by the gang. He comes for a photo lineup. He's giving evidence of who hurt him. The gang is not pleased. When the gang members learned that Malone had cooperated with the authorities, Johnson ordered that Malone be killed. The Baltimore City Police Department, wonderful guys there in Baltimore, took Malone into protective custody, but Malone was later evicted from witness protection program because of a rules infraction, was killed shortly thereafter. So outstanding witness protection you have there. Oh yeah, we will protect you. Oh, you committed a rule violation. Okay, we're going to kick you out, and then he was murdered. Way to go, Baltimore. Just genius work. Great job. Notably, Malone's police department contact had received a tip that Malone was in imminent danger on the night of his death, but the authorities were unable to intercept him in time to save his life. Good job, police. The jury was showed graphic photographs depicting Malone's body after he was murdered. On December the 7th, 2017, immediately after hearing testimony recounting the police department's frantic efforts to prevent the murder, not that great. Members of the jury contacted the courtroom deputy clerk. So immediately after hearing this testimony, the jurors are now contacting the clerk. Okay. The jurors expressed concern. Defendant had been exchanging notes with the attorney and paralegal, and then had looked up at the jury. The court observed that the jurors' apprehension was the potential effect of a reasonable person of the sort of evidence that had been presented. So the jurors are seeing this person take notes, and they're concerned, and so they're indicating their concern to the court clerk. All right, so far, let's carry on. Later the same day, one or more jurors approached the courtroom clerk with concerns the defendants had received access to jurors' personal information during voir dire. That can definitely happen, yes. After courts adjourned for the day, the jurors gave a note to the courtroom clerk stating that they were concerned about the info the defense may have from a personal safety perspective. So they are also concerned about potentially being retaliated against as members of this jury. The court concluded the jurors' concerns were of a generalized nature, not of such a severity and specificity to warrant a voir dire to try to assess the feelings. So the jurors are concerned, but not concerned enough for us to look into it, says the trial court. All right. With respect to the three concerns raised by the jurors on December the 7th, 2017, the district court denied the defendant's request for a mistrial or to conduct a voir dire of the jury members. Instead, the court provided certain witness assurances to the jurors regarding standard procedures. Yeah, those assurances must sound really, really good in light of the fact that this dead guy was in witness protection and then, not so much. So the assurances from the court, I'm sure, are making them feel all the kinds of better, yes. On January the 9th, 2018, the 19th day of the trial, a court security officer advised the court that a juror had told him, in front of the rest of all the jurors, that some of the defendant's associates had attempted to photograph the jurors as they entered a public hallway from the jury room. So one of the jurors has said, as we were entering in this public hallway, we noticed that people are taking photographs of us. This concerns us. Okay. The court immediately asked the government whether there may be an effort afoot to tamper or intimidate a juror. No. Because why else does someone snap pictures of a juror going in and out of a jury room? Good question. Government counsel confirmed the group of people who had congregated in the area in question were family members of or witnesses for the defendants. So these people who were allegedly doing these things were associated with the defendants who were on trial, who may be taking photographs of the jurors for no particular reason, I'm sure. The defendant moved for a mistrial, arguing the jury could not fairly evaluate the testimony of the witnesses after jurors had expressed concerns that the witnesses were dangerous. Yeah, that's a little bit concerning. So we have things that are extrinsic to the trial coming into the trial, and so that makes things a bit problematic. All right, so let's press on. After conducting these interviews, the court staff informed the court and counsel that a single juror, juror number 4, had reported seeing 2 women use their cell phones to take photographs of the jurors. Juror number 4 described the women as holding the phone chest high and pointing them outward while looking at the jurors instead of at the phone. After making this observation, juror number 4 reported her suspicion to some of the other jurors. 3 jurors reported seeing people hold phones in the hallway, but they did not think those individuals were taking pictures. Another 3 jurors stated that they had reported them someone, possibly the mother of one of the defendants, had been taking pictures surreptitiously. According to the jurors, juror number 4 stated, "Guys, this is really serious. They're taking pictures of us." After considering these reports from the court staff, the district court determined that there was no corroboration for juror 4's concerns or observations in the statements of any other jurors, any court security officer, or any other information that had been brought to the court's attention. So my conclusion, the court's conclusion, is that there's not evidence before the court at this point that there's any actual photograph taking place that was going on. The court was nevertheless concerned that juror 4 may well believe something was going on that could influence the juror's experience here and consequently cause the juror's judgment with respect to the case. The court therefore dismissed juror number 4 from service of the jury, but did not explain the absence to the remaining members of the jury. The court declined defendant's request to conduct a voir dire of other jurors, concluding there's not a significant basis for concern. So the judge here is looking at some of these things and saying, well, juror number 4 expressed some concern. But the juror number 4 apparently expressed this concern in front of the rest of the jury. So what I'm going to do is just dismiss juror number 4 without any explanation to other members of the jury. This one juror who had said there might be a problem here, who now suddenly disappears. And I'm not going to explain it in any way. It doesn't take a lot of mental math to figure out that might present a problem. If the one person who said, hey, we might be under threat suddenly disappears, Would that cause you to have some concern if you were a member of the jury? I'm thinking it would. I'm not thinking the district court necessarily handled this the best possible way. The United States Marshal Service, together with the United States Attorney's Office, conducted further investigation of the reported photographing incident after court adjourned for the day. The deputy marshals searched the cell phones of one of the individuals, but they did not discover any photo images on the cell phone. When the deputy marshal reported to the court the next morning the results of the inquiry, the court noted that this information further supports the court's conclusion that the incident reported by juror number 4 had been handled properly, with a minimum of fanfare, and neither individual voir dire nor a mistrial was warranted. The court orally informed the jurors that reporting the incident had been investigated and no photographs had been found, and the jury returned a verdict of guilty on all the charges. So we have some things happening during the trial where the people may or may not being photographed. They searched one of the phones. There was no photographs on at least one of them, but doesn't necessarily mean anything, right? It could be on other phones, or it could have been uploaded to the cloud, not on the device. Insert your own way that it might not be there at the time. But we have solved the problem. We've dismissed the one squeaky wheel juror, and we have got our criminal conviction. So we are all good to go. So now the Court of Appeals has to figure out whether or not any of this renders this verdict questionable. So let's read what the Court of Appeals has to say about the jury's verdict and whether or not it can be sustained given the facts. The defendants argue the district court abused its discretion when it failed to conduct a Remmer hearing to evaluate whether the jurors could remain impartial after the reported cell phone incident. The defendants emphasized that the reported incident occurred after jurors had already expressed fear of the defendant on more than one occasion. According to the defendants, the jurors' multiple reports regarding their fear of the defendants, including one of the jurors concerned that the defendant's associates had taken photographs of the jury, were external influences that, under Remmer, entitled them to a presumption of prejudice and an evidentiary hearing. In response, the government contends although the district court declined to conduct a Remmer hearing, the court nevertheless took adequate steps to ensure juror impartiality. In the government's view, the court acted within its discretion by dismissing the single juror who reported the alleged photograph and informing the remaining jurors that, in fact, no photograph had been taken. So, as you might expect, this is not the first time that something like this has happened, and there have been court decisions already on this issue when there are these external influences and how you handle that when an ongoing trial. And so there is a case that we're going to discuss in just a second that outlines some of this stuff, and the court didn't follow that process. They instead did something basically off the cuff. So the government is arguing that this process the court essentially invented on their own initiative is enough. And the defense say, well, no, actually there's case law on this that says how you're supposed to do this, and that wasn't done. So we don't know whether or not the jury was able to reach a fair verdict. Okay. The defendant's Sixth Amendment right to a trial by an impartial jury is violated if an influence outside the jury's deliberative process, an external influence, affects the decision-making. If even a single juror's impartiality is overcome by the external influence, the defendant's right to an impartial jury has been compromised. In Remmer, the Supreme Court established procedure a district court must follow when there has been direct or indirect private communication, contact, or tampering with a juror during a trial about a matter pending before the court. A defendant seeking this hearing must present credible allegation that unauthorized contact was made, and contact was such a character as to reasonably draw into question the integrity of the trial proceedings constitute more than an innocuous intervention. So there is a standard for this. There are things that you do, and so you look to whether or not there's been improper contact between the defendant, the attorneys, anyone else, between anyone basically and the juror. Has there been improper contact? And there is an exception here for innocuous contact. So, if they happen to be like in the same elevator, I can't imagine that happening. But if that wouldn't qualify. You need something a little bit more explicit than that. But not a whole lot more. You need just some sort of thing that raises the problem that there is this issue. And if so, there's a procedure to deal with it. Okay. If the defendant makes the threshold showing, the defendant is entitled under Remmer to a rebuttable presumption the external influence prejudiced the juror's ability to remain impartial, and to a hearing to determine what actually transpired and whether the contact was harmless. At such a hearing, the government bears the burden of rebutting the presumption of prejudice by showing that there is no reasonable possibility the juror was influenced by the improper communication. So it's a pretty high standard to favor due process and favor the impartiality of the jury. So here you have to show that that it, that it wasn't bad, and the government has to show that convincingly, that any reasonable explanation shows it wasn't a problem, and they weren't able to show that here because they never had the hearing here. Applying these principles, we consider where the district court received a credible allegation of a non-innocuous external influence requiring the court to hold the evidentiary hearing under Ramir. In conducting our analysis, we focus on the alleged photographing incident reported by juror number 4, the most serious claim regarding the juror's ability to remain impartial. We think it is beyond dispute that a juror's report of juror members being photographed by the defense associates during the trial involving murder witnesses, and the juror's act of conveying this information to other jurors were more than innocuous interventions, and the conduct was of such a character as to reasonably draw into question the abilities of the juror to remain impartial. This does seem like the kind of thing that's a problem, particularly when it was reported to other members of the jury. If they just reported to other themselves or whatever, that would have been different. But now all the members of the jury know. And so that is going to be something that is potentially worthy of examination. Yes, that wasn't done. The district court immediately recognized the seriousness of juror number 4's allegations. As noted above, after receiving juror number 4's report of photograph being taken, the court questioned whether there may be an effort afoot to tamper with or intimidate a juror, because why does someone else snap pictures going in and out of the jury room? Given the plainly prejudicial nature of the allegation, the court's response reflecting the assessment was credible. The criteria for the Ramir hearing was met. The district court's management of this incident was flawed both procedurally and substantively, and therefore failed to comply with the requirements of Ramir. Procedurally, the district court erred in delegating to its staff the responsibility of questioning the jurors. A court confronted with a credible allegation of improper external contact may not rely on ex parte third-party information. Instead, a judge must determine the circumstances, the impact thereof on the juror, and whether or not it was prejudicial in a hearing with all the interested parties permitted to participate. So here, this is supposed to be an open process where things are being done in an open way for the record. And one of the problems here is that the judge asked his staff to investigate it without it being open, without the opportunity to ask questions, without the ability to confront. And so there was due process denied to both sides in trying to decide what is or was not the impact of this. Thus, the procedure employed by the district court disregarded the fact-finding purpose of the Ramir hearing, which is based on the considerations of due process. As we emphasized in Barnes, without a hearing, a criminal defendant is deprived of the opportunity to uncover facts that could prove the Sixth Amendment violation. So without the ability to confront and ask questions, you can't get the evidence needed to show there's been a problem. The procedure also deprived the defendants of presumption of prejudice, to which they're entitled under Ramir. The investigation directed by the district court was also substantively deficient. The court engaged in an abbreviated consideration of juror number 4's allegation and took unduly narrow views of the type of external context that would mandate a Ramir hearing. Although juror number 4 had alleged that 2 persons had used their cell phones to take photographs of the juror, only one of the phones was examined to determine whether the photographs were taken. Moreover, by focusing on the question of whether photographs in fact had been taken, and failing to consider whether the defendant's associates had in any way intimidated the jurors by displaying their cell phones, the district court failed to consider the effect on the jurors of the perceived external conduct. A third party's threat or attempt to take a photograph may be no less intimidating than actually taking the photograph. So the district court erred by, for example, only looking for the devices to see whether or not there was a photograph on them. Because whether or not a photograph was actually taken or not is not necessarily the end of the issue. We're looking to the intimidation of the jury. We're looking to whether or not they're compromised. And if the juror believes their photograph is being taken, even if it isn't being taken, then that belief may influence their deliberations in an improper way. So the judge erred by failing to consider the impact on the juror rather than objectively what happened. The perception of what happened is more important than the reality when it comes to looking to what the juror is or is not going to be biased in the trial. Thus, the question of whether a photograph was taken is not dispositive of the inquiry, as one or more jurors may have felt intimidated regardless. By limiting its inquiry to actual existence of the photograph, the district court left key substantive matters unresolved, namely, whether anyone had attempted or threatened to take a photograph, the identity of the alleged actors and their relationship to the case, and the impact of juror number 4's statements on other members of the jury, which is probably the most important thing, all things being considered. Because the other juror relaying this information to other members of the jury. Again, regardless of whether the photograph was in fact taken, it doesn't matter. Now, other members of the jury believe it happened or may believe it happened. And so that may influence their decision one way or another. So that statement from one juror to another juror is something that has potentially caused a problem for the jury pool. The district court concluded that juror number 4 may well believe that, in fact, something was going on, and that could influence the juror's experience here and consequently the juror's judgment with respect to the case. The problem could apply equally to any jurors who heard the statement, regardless of whether they had witnessed anything personally. Without questioning each juror individually, the district court could not know whether any remaining jurors were prejudiced by the stated concerns, even if those jurors had not witnessed anything themselves. Yeah, just because you didn't see anything, if you heard a report of it from another member of the jury, it's something being brought in that's external to the case. So you now have evidence that you didn't have before. It may be causing you to think differently. This may present a problem. So whether or not photographs were actually taken, whether or not these people actually existed, whether or not there were actually cell phones, doesn't really matter that much. The juror believed it to be true and has reported it to other people as though it were true. So we have to figure out what is going on in terms of the impact of that. The truth of the underlying thing is a little bit neither here nor there at this point. The potentially widespread taint of the jury compelled the district court to conduct the Ramir hearing, which it didn't. We do not casually invoke the requirements of Ramir, and we acknowledge the district court was required to maintain a challenging and lengthy trial with jurors who were understandably unsettled by violent acts committed by the defendants and others. Nevertheless, we reached the firm conclusion the defendants were entitled to an evidentiary hearing under Ramir to determine whether all the jurors remained impartial throughout the case, as guaranteed by the Sixth Amendment. For these reasons, we vacate the district court's judgment. We therefore remand the case to the district court to conduct an evidentiary hearing in accordance with the requirements of Ramir and for other such proceedings consistent with the principles expressed in this opinion. So that is the case of the United States of America versus Gerald Thompson Johnson. It looks like Mr. Johnson is going to get another bite at the apple. With the district court's decision vacated, it looks like we're going back to trial and trying to do this all over again. So we're going to have to try this again from square one, I suppose, because the decision has been vacated. So we're going to go back to trial and call the witnesses again and get a new jury and do this whole thing over again. So the conviction has been vacated because the district court didn't follow through the proper processes and the jury was tainted and it caused the result to be questionable. So Mr. Johnson gets another bite at the apple and his gang days may or may not be continuing, but for the moment at least, that's the end of our coverage of this case.